Welcome back to Opening Statements. I'm Julie Grant. This morning, we're spotlighting serious allegations of prosecutorial misconduct coming from defendant Jennifer Crumbley, the mother of Oxford school shooter Ethan Crumbley. Now, her defense attorney, Michael Desi, claims that the prosecution conducted what he calls a smear campaign to influence public opinion ahead of Jennifer Crumbley's trial. Desi alleges that the prosecution spent over $100,000 on public relations firms to manage the narrative surrounding the case. He argues this behavior has undermined Crumbley's right to a fair trial, highlighting concerns over secret deals with key witnesses that weren't disclosed, he says, during the proceedings. Now, Jennifer and James Crumbley, you may recall, were both convicted of involuntary manslaughter for their role in the deaths of 4 Oxford high school students.
Of course, I look back after this all happened, and I've asked myself if I would have done anything differently, and I wouldn't have.
If you could change what happened, would you?
Oh, absolutely. I wish he would have killed us instead.
We all remember that moment, right? Well, Jennifer Crumbley is currently appealing her conviction, asking the court to release her, too, while her appeal is pending. She's scheduled to be back in court on January 31st. I want to welcome now her attorney onto the program, attorney Michael Desi, who is representing her in her appellate matters. Michael, good morning to you. Thank you for coming on the program.
Good morning. Thank you for having me, Julie.
Certainly. So let's start with what you call this smear campaign. Tell us, please, Michael, how do you know about this alleged campaign?
Sure. So what we have found out is that the prosecution's office had retained 2 PR firms to handle what they've called managing the media and conveying messaging out to a national platform. We only found that out recently because we had sent requests to the county asking for documents surrounding the case and the prosecution, and one of those contracts was produced to us through that process. So we only have one of the contracts. There were 2 PR public relations firms that were retained by the prosecution. One of them was for a contract amount of $100,000. I don't yet have the amount for the second PR firm. But interestingly enough, on one of the PR firms, they actually openly discussed and disclosed the fact that they were retained within hours of the shooting. So, I find that both shocking and somewhat problematic in the sense that the court had issued 3 gag orders in this case that prohibited both parties, the prosecution and the defense, from providing any pretrial publicity out to the media, anything that could taint the potential jury pool. So, we didn't know that there was this type of coordinated effort to conduct what I'm calling a smear campaign to put out the prosecution's narratives out into the public. And they essentially did what they couldn't do directly because of the court orders. They did it indirectly by using these PR firms.
And would you go a little further, please, Michael? What specifically did these PR firms do?
So I can only tell you what these PR firms have disclosed that they did, but according to what they posted on their own websites, they essentially acted as a liaison between the prosecutor's office and larger national media outlets and other media talking heads and pundits, some of the talk shows and whatnot that they believed were favorable to them. So they could pick and choose which media outlets they thought might be the best to push their narrative about the case. And of course, there was so much negative publicity about the Crumbleys leading up to the trial. I mean, it would be impossible to say that this did not have some effect on the jury that was brought in ultimately to hear the case.
Michael, would you tell us more about what you say are secret deals with key witnesses?
Sure. So the prosecution at trial, they relied on 2 key school officials, and those school officials were the last individuals that had contact with the shooter and also with the Crumbley, the parents. What we didn't know is that when those school officials came into trial to testify earlier last year, they had cooperation agreements, essentially a form of use immunity agreements. And for your audience that may not know what that means, it's basically a cooperation agreement so that these witnesses said, hey, we'll come in and we'll cooperate with you and we'll talk and tell you what we know. And in return, you cannot charge us or say you take anything that we say if you were to charge us with a crime. Well, there's been lots of speculation and discussion about those school officials and whether they should have been charged for their acts and omissions arising out of the shooting. And so it should have been known to the jury. The jury should have known that those witnesses had these special agreements and that they were cooperating with the prosecution at the time that they testified, because those agreements gave them a bias and certainly a motive to testify against the Crumbleys in order to save themselves. So those agreements were required to be disclosed under Michigan law. And we only found out about those after the trial. So that is another basis for which we are asking the court to dismiss this case and throw these charges out, for the fact that the prosecution deliberately hid those agreements.
Understood. Michael, thank you for that explainer. I want to share with you and for all of our audience the statement that the prosecutor's office issued in response to the claims that you're making, saying, quote, "The two stories defense counsel references came out after the jury verdicts, not before, and the suggestion that they had any impact on the jury is ridiculous. Jennifer Crumbley was convicted for what she did and didn't do, and the defense cannot change those facts," end quote. This was submitted by Chief Assistant Prosecutor David Williams. Michael Desi, your response to their response, please.
Yeah, you know, that's just a form of gaslighting, because that's not true and it's not accurate. They retained those PR firms to push their narrative into the national media. They also invited two other journalists in behind the scenes with them to document their case preparations. Those two journalists may have released articles after, but it doesn't change the fact that they had retained the two PR firms that were working from within hours of the shooting all through the time of the trial to put out other narratives into the media, independent of those two journalists who were embedded behind the scenes, also unknown to us at the time, because they were making documentaries when they were told by the court that they could not communicate with the media. So there's a distinction between what the media, the PR companies did, and those journalists. But again, it would be hard to say that the public at large was not affected by the smear campaign that was run by the two PR firms.
Michael, before we have to let you go, I want to ask you, please, about January 31st, the next court day that your client, Jennifer Crumbley, is going to be present before the judge. What can we expect to happen on that date?
Well, it's hard to tell. There's a lot of issues before the court. The judge is going to decide whether to throw the case out, whether to grant a new trial, and also whether to release Ms. Crumbley while we pursue these appeal process if necessary.
Michael Desi, appreciate the conversation and appreciate you sharing your perspective with us. We'll continue the conversation and be following up on that court date on January 31st. Thank you kindly.